Hey everyone, Mark Meckler here, and I'm excited to introduce you to this video. This is me sitting down with my good friend, one of my mentors, and I think an American hero, Mike Farris. Mike Farris is the guy that founded the Homeschool Legal Defense Association and helped legalize homeschooling in America. He founded Patrick Henry College, one of the great Christian liberal arts colleges in the United States of America. He was the president of Alliance Defending Freedom, took 13 cases to the Supreme Court and won 12 of them. And the accolades go on and on. But I had a chance to sit down with him, talk a little bit about the history of COS, talk about some of the objections that we regularly hear out there when we're in the legislatures or working with grassroots across the country. He answered all those questions and more. I think you're really going to enjoy this video. And by the way, if you enjoyed this video at the end, make sure you go to conventionofstates.com/act, get signed up to hear about our weekly training calls and get involved.
It is great to see all of our COS supporters out there. Thank you so much for coming. We're super excited that you are here to join us today for a very special edition of what we have traditionally called our district captain training call. And sometimes you just need a little inspiration. Sometimes it's great to talk with the people that started it all in order to find out what's going on. We've broadened. We've been at this DC training call for just about 10 years. For the entire time we've been around, there's lots of reasons why we have kept this call going. We're very excited tonight to do something very different. And we hope that you called your friends. You still can. We hope that you called the people in your teams, in your organizations, the people that you get shoulder to shoulder with in Convention of States to watch this incredible conversation that's about to transpire between Mark Meckler, our founder, and our co-founder, I should say, our co-founder, Mark Meckler, along with the co-founder, Mike Farris. It's a really amazing time to have that conversation. I was privileged to be in the room when the discussion about this idea that Mike had ensued. And I happened to have the incredible plan that Michael Farris put together about this. He called it the Article 5 Project. And the goal was to call a convention of the states to propose binding amendments to the Constitution, which will reduce the power and size of the federal government, and then ensure that these amendments are ratified by the legislatures in 38 states. Our goal is to make the Constitution, rather than the institutions in Washington, D.C., to truly be the supreme law of the land. That was what he was thinking before we even begun Convention of States. The rest of this reads like a history book. It's really exciting to know that in 10 years, we've made some great progress. Of course, we have 19 states that have passed that resolution on the way to convention. And some things that, many of you have seen Mark, maybe a little bit more than Mike, who is our senior advisor, and he flies all over the nation to appear in court because he is the subject matter expert on Article 5. He is an incredible constitutional attorney. He has argued at the Supreme Court level. He's had decisions handed down as part of many courts, including the Supreme Court. As I mentioned, he's co-founder of Convention of States. He's a published constitutional scholar. Maybe you've seen the Harvard Journal of Law and Public Policy. It says, defining conventional wisdom, the Constitution was not the product of a runaway convention, a peer-reviewed treatise, if you will, on why the Constitution was legitimately put together. One of many scholarly works that Michael Farris has done. He's the founder of the Homeschool Legal Defense Association. He is responsible through that organization for making homeschooling legal in all 50 states. He then founded Patrick Henry College in Purcellville, Virginia. He's been the CEO of Alliance Defending Freedom. And now what I'd like to do is I'd like to bring on Mark Meckler and Mike Farris. I'll turn it over to them to have a conversation. And in the meantime, if you have some questions that are in context during the conversation, go ahead and put them in the chat, and we'll try to bring them up at the end if we have any time for that. But for now, I would like to turn it over to you, Mark and Mike. Thanks so much for being here.
Thanks for the introduction. And I am so excited about this conversation because I want to give you guys a little history. I mean, a lot of you guys have been with us a long time. Not many since the very beginning. Two of us since the very, very beginning. And you're looking at the old guys right here. And so I want to give Mike, I'm going to start with a little bit of background from Well, actually, let's start with you because you go even further back than me. You've done a lot of stuff in your career. Founder of Homeschool Legal Defense Association, fighting for the right of parents to school their kids in the way they see fit. Founded Patrick Henry College, and then at some point you decided something else had to be done with our system of government. It wasn't working the way it was intended to work, and you started to delve into this idea of using Article 5. Why don't you talk about your thought process before you and I even met?
Well, sure, Mark. It's great to be with you and great to see all the attendees and the district captains and the volunteers and the people who really make COS a reality on a day-to-day basis and give me hope for the future of the country. So I practiced constitutional law full-time since 1980. I've been a lawyer. I was doing all kinds of work for the first 4 years, but since 1980, I've been doing full-time constitutional litigation. And I also taught constitutional law at Patrick Henry College for 17 years. And especially there, I realized how much of the problems that we face in the country are just simply a misuse of constitutional structure and authority. And if we have the ability to curtail the problems with interpreting the Constitution incorrectly, we really stop the runaway government. You can call it anything you want. You can call it the swamp. You can call it runaway government. You can call it, we're on the precipice. There are many ways to describe a government that's gotten way too big. And the basic problem is we don't know what the purpose of government is anymore. If you think the purpose of government is to provide for your needs, you end up with socialism, and you end up not only broke, you end up in shackles. And so there's just a natural progression, and we are progressing rapidly in that direction. And I wanted to do something about it. I grew up, frankly, watching the men in my church have potluck suppers, and they get around and talk about solving the problems of the church and then solving the problems of the city and the state and the nation and the world. And they had some pretty good ideas from time to time. They never did a blessed thing. It just drove me crazy. And so when I see a problem, I'm just wired to want to do something about it. And so there is a solution the founders gave us, and I believe that it's real, and I believe it can be done. And I've been involved enough in politics and law and trying to change the law to make it match the freedom reality we wanted, particularly in the homeschool world. Everybody said it's impossible to legalize homeschooling in all 50 states. And I said, just watch what God and God's people can do. And it took 25 years, but what God and God's people can do was to make the recognition of homeschooling real in all 50 states. It was always legal, but the government just didn't figure that out. But we got it recognized. And so I believe this is just as real as that, just as uphill as that, but just as real as that. And the solution for our country is enormous. It's the whole freedom game that we're trying to impact in a way that nothing else has the potential to save it in the way that this does.
So, Mike, what's interesting to me about this whole thought process is, and I know you this way, you're a fixer. So you're like, how do I fix this? How'd you come to Article 5? I'm a lawyer. I went to law school. Yeah. I don't think I had any inkling that you could use Article 5 to do this. I discovered Article 5 about a year before I met you, which is in me, God's intervention, preparing me to meet you. But I didn't really think you could do it. I participated, I co-hosted a conference at Harvard Law with Larry Lessig on the idea of using Article 5. And I thought, okay, that's interesting. I'd never thought of that, but I was a skeptic, not a skeptic in the sense I was afraid of it or worried about it, but I was a skeptic in like, can you actually do that? I mean, it seems like it's such a high bar and there are other things we need to worry about. But somehow you discovered that tool and said, no, this is it. This is the right tool in the toolkit.
Well, I got my attention to Article 5 in general pretty young as a lawyer. I was about 2 years out of law school when Congress passed an extension of time for the Equal Rights Amendment. And I was getting involved. I was still in private practice, but I was getting involved in more and more conservative political activity and legal activity in Washington State. And this lady named Dottie Roberts called me up, and Dottie, earlier in her life, before she became a Christian, had smoked a lot. So I can never tell the story without doing Dottie's smoker's voice. She said, Mike, Congress just passed the extension of time on the ERA. What do you think about that? And I said, well, Dottie, I think it's unconstitutional. She said, so what are you going to do about that? And nothing was not an acceptable answer to Dottie Roberts. And so I filed the first lawsuit challenging the constitutionality of Congress's bill. They passed it by a simple majority vote to change the rules for ratifying the Equal Rights Amendment. I represented 4 Washington state legislators. I had the good sense to dismiss my original case about 2 weeks after I filed it and moved it to federal district court in Idaho, where a very similar case had been filed by the Attorney General of Idaho and other team members, and they were representing Idaho and Arizona legislators. And so we all worked together. I still, had a speaking role in the case, but I was 2 years out of law school. I had no business being lead counsel on that. And so it was, but I got help, and it was great. But I did an in-depth immersion in Article 5. In fact, I went to National Archives during those days and held in my hand the actual ratification papers for every constitutional amendment, starting with the 13th Amendment and going forward in the future to the modern times, to looking at it, because part of the arguments of the ERA were that the ratification documents weren't done correctly. And so we were just comparing what had been done. So I actually went to the National Archives and I'm probably the only person that's done that, looked at every single amendments and ratification documents. So, I just got immersed in Article 5, so I didn't know all of it. We weren't in the Convention of States process then, but if you're going to litigate Article 5, you got to know what the whole thing is. And that's how I got involved.
So another interesting part of the story that I think most people don't know, which kind of surprised me because I bought it hook, line, and sinker when you told me, is you went to other organizations first. I mean, Convention of States was not your first stop. When you and I started to work together, and we didn't have Convention of States as an organization. We had Citizens for Self-Governance. We were not very prominent. So you had gone other places first and kind of pitched this idea around, right?
Yeah, that's essentially correct. I went to a meeting in Denver. Rob Nadelson was there. Some people that had been behind the balanced budget amendment efforts were there. And we were just talking about, the BBA and, related Article 5 kind of ideas. And I started looking at the aggregation issue relative to the balanced budget amendment, because they were passing them in such different ways that I thought there was going to be litigation. And some of them were close calls, and some of them, the good guys were probably going to lose. And
Mike, can you explain real briefly what aggregation is for people who don't understand that?
Sure. When different states pass the same bill, the question is, are they close enough so that they all count for the same purpose? When the House and the Senate, whether it's in Congress or a state legislature, passes a bill, the normal rule is both legislative bodies have to pass the exact same bill for it to aggregate together and count as one bill. And so applying that standard to the Equal Rights Amendment, I went through that. For example, in that ERA litigation, the hilarious thing is the National Organization for Women sent out a ratification document that was a model ratification document, and it contained errors in the text of the ERA. They left a couple words out, they had the punctuation wrong, and a bunch of states didn't ratify the real ERA. They ratified the model put out by the National Organization for Women.
Gosh.
So I was sensitive to this aggregation issue from all of that. And I started looking at them and seeing, well, how close are these? And so I made 2 arguments. One was, look at these are going to be contested issues, and you may win, you may lose. Secondly, and more importantly, if you're going to actually ratify it, you need to have 34 states that have, in roughly the same period of time, come together, so you have a chance of getting 38 to ratify. Because if you're taking something from 50 years ago or 75 years ago and trying to base that on your call for the convention, it says nothing about, for example, right now there's a Convention of States application valid from Massachusetts for a right to life convention. Well, if we called if we got to 34 somehow, there was a right to life convention, you think Massachusetts would send a pro-life delegation to the convention? No, that ain't going to happen. So my argument was, why don't we do it right and do two things right? One, let's broaden it out a little bit, because the problem is bigger than a balanced budget. It's spending controls, it's power grabs, it's bigger. And secondly, let's do it with precision, so that the exact same operative language is done in all 34 states. And so, got some, reluctance from the people who've been at this for a while, and they kind of hemmed and hawed. And I just said, okay, well, thanks for your interest, guys. Let's go do this differently. And that's when I met you.
Yeah. And so amazingly, the way Mike and I met is through a mutual friend, and his name's Tim Dunn. Tim is one of the founding board members, Citizens for Self-Governance, one of the reasons that we have the Convention of States Project. And it's really, I got to give credit where it's due. It's really Tim's wife, Terry, that said, Mark and Mike really ought to meet. And so Tim Dunn, a dear friend of both of ours, introduced us, and you pitched me on the idea of it. And Mike Ruthenberg showed us a document earlier, which was your original plan for Convention of States. And you spent about an hour on the phone with me, and I was immediately in. And I want people to understand why I was so in and so fast. First is, I was looking like you for a fix, because I had been one of the leaders of the Tea Party movement. And what I saw is electing people wasn't enough. And I was worried about the future of our country for my kids. At the time, my kids were probably, I want to say 12 or 13 and 15. And so I'm looking forward to their future, and I'm seeing things not going well, and not going well after an excellent election. And so I'm thinking, okay, well, if that's not enough, I just poured my entire life, literally my life savings into all of that, and it didn't fix the problem. So now what? And so I'm looking for a fix. I'm a business guy. Unlike you, I'm not a scholar. Like I've built a bunch of businesses. And so that's how I think of things. It's a problem. It needs a solution. You got to have a business plan. And one of the things that you did that was so amazing to me, it wasn't just an idea. And I think when I talk to a lot of scholars, Mike, I think you're very different. I think part of the reason you're different is because you've been engaged in politics. You ran for lieutenant governor. You really understand systems. You're not just theoretical. And so you had actually designed a way that not only could you explain Article 5, but you could explain how we could get it done. And one of the most fascinating things and interesting things to me was, I had this network from the Tea Party. You had a network from homeschool movement, and we were able to some extent, combine those and think, okay, we could probably build a grassroots army out of this and get this done. Mike also had expertise in real grassroots politics. So he understood this was going to take a muscular grassroots effort. Like a lot of people who come up with ideas, they don't really understand grassroots. They know it's going to take a lot of people. They have no idea how to do grassroots. You would actually are a pioneer in a grassroots movement. So you understood all that. So now here we are. It's 11 years later, actually, at this point. We've passed 19 states. It's been hard. One of the things you said early on that helps me to keep perspective is 25 years at homeschooling, like at pushing that movement. So here we are. We're less than halfway in there on that. And I know it's hard, and I know it takes a long time. I want to talk about the objections and the things that keep people from going along with this idea. And by people, I mean people who should be on our side, some conservatives. And the primary argument that I would hear, and I say this is I want to say I get this is 90% of the objection. There's 10% of other marginal things, but it's 90%, is that if we call a convention, we're going to have a runaway convention and we're going to lose our Constitution. And so I want to start at sort of step one of where do people say that comes from? The people who say they have some basis for this say in 1787, these great founding fathers got together for a convention, and that their only purpose in gathering was to propose amendments to the Articles of Confederation, but that convention ran away. They disobeyed what they were told to do. and they gave us this new constitution, including a new ratification method. And it's the weirdest argument to me, Mike, and I know you find this as offensive as I do. They say about those framers, they're incredible guys. They gave us this wonderful gift, but it was all illegal. They were a bunch of criminals and scalawags. So that's the argument that gets made. And I know that frustrated you so much. I remember you said at one point to me, Mark, I'm going to spend the entire summer face down in the library, and I'm going to push back on this idea that 1787 was a runaway convention. Can you talk about that process and what you found?
Sure. Well, you have to start the story at the Annapolis Convention. And so a handful of states met. It was about 5 states met. Their purpose was to discuss problems of commerce. And the commerce in those days trade across state lines. And it's what it still should be from a constitutional perspective.
Right.
And so they got together and they realized 2 things. First, they don't have enough authority. The states had called them there. The states had given their instructions. They didn't have enough authority. And so they weren't about to violate the authority given to them by the states. And so they said, well, let's come back again in Philadelphia in May of 1787. And let's ask our states for authority to do this. And the recommendation was to render the federal constitution adequate for the exigencies of the Union. Now, the language only amend the Articles of Confederation comes from a completely different source. It comes from the Congress of that was meeting under the Articles of Confederation. Now, if anybody would bother to read the Articles of Confederation, you'd realize that Congress didn't have any power to do anything implied at all. I mean, that was one of the problems, is they had no powers that were commensurate to the things that they were needing to face. And so there were no implied powers. There were no powers to call a convention. They did not call a convention. The states called the convention. And so it started with Virginia. Virginia was the first to pass a call for the convention using the language, render the federal constitution adequate for the exigencies of the Union. And a total of 6 states did exactly the same thing before Congress basically endorsed the idea. They endorsed the idea with this resolution, but they gave their opinion that the convention should only amend the Articles of Confederation. But it wasn't the official call for the convention. It's not what gave the delegates their authority. And so if the delegates violated their authority, it's you compare what they did to what their states told them to do. In fact, if you read the debates of the Constitutional Convention, Madison has notes, or a few other notes that are in existence. And that question came up, and every single time it came up, they said, well, let's go read our credentials from our states. And so it was the states that called the convention. It was the states that gave them their authority. 12 states showed up. Rhode Island, they chose not to come, didn't have to. And the 10 states, 9 states exactly did what Virginia did, total of 9. Connecticut basically just paraphrased it. New York followed what Congress said. And Massachusetts did both. It did what Virginia said and what Congress said. So it's a little bit up in the air. Now, New York didn't vote after July. Once it became clear that they were going to write a new document, 2 guys from New York went home, and under the rules by the New York legislature, unless all 3 delegates were there, New York ballots couldn't be cast. So Alexander Hamilton stayed and debated, but he never cast a vote for New York. So New York delegates obeyed their instructions. There was a resolution in Massachusetts at the ratification convention saying that they should condemn their delegates for violating their instructions. And there was a vote taken by the Massachusetts ratification convention on that question. And by an overwhelming majority, by about a 2-to-1 margin, the people in Massachusetts said, no, they obeyed their instructions. So if the best evidence of whether the Massachusetts people obeyed their instructions is what those people in Massachusetts said in immediate aftermath of what had happened. And so the question of whether they obeyed their instructions It's really clear. They obeyed their instructions. Second was changing the ratification process. Congress did not have, excuse me, I should say the convention rather, the articles of the convention held in Philadelphia, the Constitutional Convention, did not pass only one document. It passed two documents. The first document was the Constitution itself, which is a recommendation. The second document was a recommendation on the new process. And they sent both of those documents to the Congress in Philadelphia.
Right.
And the Congress in Philadelphia voted only on the recommendation of the new process. They approved it unanimously. And then they sent it out to the 13 state legislatures to authenticate the new process. All 13 state legislatures, including Rhode Island and North Carolina, that originally rejected the Constitution, all of them approved the new process. And so the question of whether they followed the process, how were you supposed to change the process under the Articles of Confederation? Congress was supposed to unanimously approve it. All 13 states were supposed to unanimously approve it. How did we get the new process for the Constitution? Exactly that same way. Congress approved it completely, 100%, and 100% of the state legislatures voted to use the new process. So both from a substance perspective, what authority did they have, and the process they got to, they did it exactly right. And they didn't really mean to exactly. I think it was God's mercy and guidance,
right,
because Alexander Hamilton and James Madison were generally really aligned. But when it came to the ratification process, they were enemies on that question, or opponents, I should say, probably. And basically, Hamilton wanted to do it one way and Madison wanted to do it the other way. And they finally said, okay, let's do both. And so they sent it to the Congress and they sent it to the states and did both. And by doing both, that was the right answer. That was the legally correct answer that they kind of stumbled onto, because they said, okay, we got these two great guys and let's just do both.
Yeah, Mike, I've heard Madison quoted by our opponents saying that Madison said, or others at convention said, that the delegations exceeded their authority. Did you find any evidence for that?
No, there's no evidence whatsoever of that. And, there are people who have been saying that from the beginning. The people who've been saying it most recently, the person most responsible for it in my lifetime saying that was Chief Justice of the United States, Earl Warren. Excuse me, Warren Burger.
Yep.
Yeah. They're birds of a feather, I might say. But Warren Burger, by the way, was the mastermind of Roe versus Wade. And he assigned it to Blackmun to write, but he was the mastermind behind it. And at the time he started campaigning against using Article 5 in this way, there were 19 states that had resolutions to call for an Article 5 convention on the question of reversing Roe versus Wade. And Berger became friends with Phyllis Schlafly when they were both on the bicentennial of the Constitution. And in that capacity, by the way, Warren Burger made a speech that the Constitution of the United States was illegally adopted. How can you be the Chief Justice of the United States Supreme Court, be the head of the bicentennial of the Constitution, and then argue it's illegally adopted? Especially since the history doesn't bear it out. You just make this assertion that they told you in school, and you don't even research it. I mean, that's the most sloppy excuse for a Chief Justice I've ever heard. But he got Phyllis Schlafly, who's a good lady, who was my friend for a long time. She's passed away now. She became an opponent of Article 5 because of the influence of Warren Burger. With her help, she got 6 states to repeal their Roe versus Wade calls for a convention. We would have had 34 if that hadn't have happened. But we had 19, and we're on a track to get to 34. But taking away 6 because of Phyllis's efforts killed it. And so millions of babies died because of fear mongering about Article 5. Trillions of dollars are being wasted. I'll never equate babies' lives with trillions of dollars, but trillions of dollars are being wasted because people are doing the same fear mongering, telling the same lies that Warren Burger said. And, you know, the chief proponent of the lies now is the John Birch Society. And the irony is the first and second presidents of the John Birch Society advocated to adopt a composite group of amendments they called the Liberty Amendment, that they were going to use the Article 5 Convention of States process to do that. So the John Birch Society founders, or excuse me, the first and second presidents, wanted to do what we're doing. So not only does the John Birch Society think the founders of the country are wrong, they think the founders of the John Birch Society are wrong. So, you know, they're smarter than the founders of their own group. They're smarter than the founders of the country. They're smarter than everybody except some rocks outside, you know.
Well, so, you know, another thing that I hear that pseudo scholars say, and there are a bunch of pseudo scholars out there. I want people to understand this. When people claim to be scholars, we had to look at the scholarly body of work that they've done over their careers. What's been published in peer-reviewed journals? Have they taught at universities? And there are a lot of universities I'm not fans of, but there are still standards to get into a lot of these universities as a professor. And so that's what we're looking for as somebody actually a constitutional attorney. And a lot of these pseudo scholars who don't have any of those qualifications, who openly admit they don't, say some pretty wild things. One thing that I hear pretty regularly is they say that Madison expressed that he was afraid of the idea of the people using Article 5, that he was opposed to the convention use of Article 5 later on. Can you address that allegation?
At the Virginia Ratification Convention, Patrick Henry was pushing really hard for a new convention to basically revise the Constitution. And he wanted amendments to be written by a new convention before the Constitution was approved, finally. What was, at least before Virginia approved it. And if Virginia had held out, it was such a big and influential state, the country would have been basically put on hold until Virginia dealt with it. And so there was a debate in the convention, basically prior amendments or subsequent amendments. And a prior convention or subsequent amendments, either through Congress or through a convention. And so Madison did not want a prior amendments convention, because he knew that if he did that, the whole deal of the Constitution would come unraveled and something else would you know, it was just too much work. So he was doing his best to salvage the Constitution. So that's almost all of his statements can be attributed to that. And then secondly, he, you know, listened to Virginia's call for a convention that was passed in 1788 and still on the books today. It says that, you know, call for a convention on a bunch of topics, you know, basically a general convention. And he didn't want that. He liked the idea of specific amendments. And so I agree with James Madison. I don't want a general convention, you know, because you could call it general convention. If 34 states said we want an open-ended constitutional amendments convention where you could write amendment on any topic whatsoever, you could do that. And that would be lawful. It'd be a bad idea politically. But when you call a convention for a particular purpose, that's a very different thing. And so Madison was talking about not wanting general conventions, especially not a general convention prior to the Virginia's adoption of the Constitution.
Yeah, I think it's important we remember historical context too. And people talk about being textualists. I like the term contextualist because it's the text plus what's going on at the time. And I think Madison rightly understood that there was still a fight going on between the anti-federalists who wanted to torpedo the entire Constitution and the Federalists, and they had barely made it out of convention, and now they're in the ratification debates. The last thing he wanted to do was open the entire thing up again to having the anti-federalists undermine the whole Constitution.
Yeah, indeed. And so, you know, Patrick Henry's objections basically were the political necessity for creating the Bill of Rights. But for that demand, we wouldn't have gotten the Bill of Rights at that point in time. And who knows what would have ever happened. but Madison had to make political promises in order to get elected to Congress, particularly some Baptist churches in Orange County and immediately surrounding areas. And he was good friends with these guys because he had been a real strong leader for religious freedom in the Virginia legislature. But they told him, look, we're not going to vote for you if you don't promise to give us a Bill of Rights that include religious freedom. And he made him a promise. And in church, violating the Johnson Amendment, these churches in 1789 voted for Patrick Henry for Congress. And so he got elected on that, and he kept his promise. He did it. He delivered the Bill of Rights. And so anyhow, that's
so that gives us context around these statements that Madison was opposed to Article 5. He was opposed under the circumstances in that current context at that time to calling a new convention. Really, was
a new general convention. He did not want a new general convention.
Right.
And no sensible person wants a new general convention today either.
Yeah, and I want to be clear about that too, because one of the things that the JABS says about us, Eagle Forum says about us, they use the term con, and they're using it. They're trying to. It's pejorative, obviously, that we've got some kind of a con going on, which I want to address that first, and I'll take that on, which is that the idea that people like Mike Farris, Rick Santorum, Senator Tom Coburn, that these are men who spent their careers in the public eye as conservatives, that they're attempting to pull over some con on the conservative public or on the public at large. It's an outrageous slander. And I feel privileged to stand in league with you guys, great names, men who've accomplished much more than me. And I look at that and I think, I have a public record, Mike, now 15 years in the public eye. There's not a single thing I said that I don't stand behind. I've been a true blue conservative the whole time. The idea that you or I are trying to con anybody, or like I said, Rick Santorum, Tom Coburn, all the different people who endorse us, that's just outrageous and offensive. So I'm just going to push that one aside. And I want to talk about the other reason they call it a con is they say that what we're trying to do is call a constitutional convention. And there is a very large difference legally between a constitutional convention and a convention for proposing amendments. Can you discuss that difference?
A constitutional convention is where you write an entirely new document. An amendments convention is limited to whatever topics you put in your application. There are about 450 applications by well more than 34 states. I think it's actually 49 states that are on the books, current, valid today. And so if topics for the call didn't matter, we would have had a whole lot of conventions by now. But we've never had one because we've never had 2/3 of the states call one on the same topic. And so an amendments convention, it starts when 34 states agree on a topic. And you're limited to that topic. People say, well, conventions have unlimited power. And I go, no, they don't. That's a ridiculous argument. The Republican National Convention cannot nominate the Democratic nominee for president, nor can they pass laws for France, nor can they amend the budget of Patrick Henry College. They just can't do those things. They can do the things that are within their framework, within their call. And a convention is exactly the same. What can an amendments convention do that's called to pass term limits, fiscal restraints, and impose jurisdictional limits on the federal government? It can do those three things. Can it increase the power of the federal government? No, it can't, because that's not germane. Can it amend the Second Amendment? No, because that's not germane. It'd be like trying to pass a law for France. You can't do it, but you haven't been brought together for that purpose. You only have the authority that you're brought together for. And the ERA litigation that I did, that's been verified by recent court decisions, because the feminists tried to revive it. It's kind of the zombie form of the ERA. It's, even though it's been in the grave now for 40 years, we're going to revive it again. And the courts have said, no, you can't change the rules in the middle of the stream. If you say 7 years, it's 7 years. So the efforts of Congress, and these are judges appointed by Obama that have also, ruled. Every judge looking at this ever has said you can't change the rules in the middle of the stream. Obama judges, and you know how much they want the ERA. And so this is one thing that no judge in our country has been willing to play games with, and that it's the process of amending the Constitution. Because they know good and well that if they let one side play games, everybody's going to play games. And the whole thing comes unraveled at that point in time. So
let's talk about the actual convention process, because I hear all the time that people are afraid. Like they say, and I get this, I don't trust anybody who's going to be sent to that convention. I don't trust my state legislators. How do I know they're not just going to go to the convention and ignore what the application says and just do whatever they want? How do I know that that's not just going to happen?
There are three answers. First of all, I don't trust anybody to decide how much power that they themselves should have. I trust if I'm going to have somebody decide how much power the federal government has, I want somebody other than the federal government deciding that question. And you've only got two choices. You can have Congress and the federal hierarchy continue to decide how much power they have, or we have a convention appointed by state legislatures to decide how much power the other guy should have. Because the founders believed that institutional jealousy, states would say, forget you guys, we're going to protect our prerogatives at the states.
Right.
And so institutional jealousy is argument number one. Number two, 34 states just sent delegates after passing resolutions for these purposes. And so, they're not going to send them there for some other purpose. They just got it done for this purpose. And so you got 34 votes right out of the gate, and you vote one state, one vote. It's impossible to get to 26 bad votes when you start with 34 votes in your pocket. Third, virtually all the states, and many states now, and by the time we get to a convention, I think all 34 will do this, passing faithful delegate rules. So that basically they're committing crimes, they can be removed, that if delegates violate their instructions, violate their authority, then they'll go to jail, or they'll lose their jobs, or they'll be fined, or all the above. And so, and fourth, I will sue them personally, and I will win again, just like I won on the ERA litigation, because you can't change the rules in the middle of the street. So there's 4 really good reasons that it ain't going to ever happen.
Yeah, I also want to add just human nature, Mike, and this is so interesting to me. People don't think about things, again, in context. If you get appointed, let's just assume it was you get appointed by the Virginia legislature to go attend what is going to be literally the biggest political event in the history of the United States. And you're going as a representative of your state. And that means your legislature trusts you, or they wouldn't put you in that position. So you're held in high esteem by the legislature. You're obviously a known commodity. The idea that you're going to go there and just say, yeah, you know what, I'm just going to do whatever I want. I don't really care what my legislature said. And there's something called a commission. The legislature will actually send you with a document that says what your limits are on your authority and things you're allowed to do and not allowed to do. The idea that any human being is just going to say, yeah, I don't really care about that. I'm here. I'm going to have fun. I'm going to do whatever I want. I'm going to ignore my legislature. That belies human nature. You would destroy your own reputation. You would have your authority removed by your legislature. And under these faithful delegate laws, you're going to face prison, fines, or both. And so it's an outrageous, ridiculous argument that this could actually happen. Now, let's just go into the fantasy realm for now. And let's say that our opponents from the John Birch Society are correct. And it gets crazy. And they pass out an amendment that you or I wouldn't like. What's the final safeguard, the final bar that the framers put in place so we know that nothing crazy is going to happen?
38 states have to vote yes in both houses. So if 13 states vote no or don't vote, do anything other than vote yes, it's dead. So if Kentucky, for example, votes yes in one house and no in another, the answer is no. or they vote yes in one house and they don't vote in the other house? The answer is no. You've got to get 2 yes votes in every state except Nebraska. You got to get 1 because they don't have a unicameral. You got to get 1 chamber only in Nebraska, but otherwise it's 2 chambers. Now the chances of that happening, it's just a political impossibility. It is so hard to get something good done. It is impossible to do anything that's crazy. I mean, there are things that I would like to write that I don't think are crazy, but I'm politically savvy enough and realistic enough to know that I'm not going to get a full reversal of the Commerce Clause. I've actually come up with an idea recently I think might work and would really be pretty good, and that is freeze it. Say no new programs using the modern theory of the Commerce Clause. Let's go back to the original theory of the Commerce Clause for anything new. And so you can't do that. So all the programs that would be generated in the future would be gone. So that's more realistic. So it's just politically impossible to do as much as I would like to do. That doesn't mean we can't do some really good things, like get rid of the Department of Education, have a single subject rule, have 9 justices only, have a balanced budget with a spending limitation bill, have a tax limitation bill, require supermajority votes for tax increases. Those kinds of things, and some form of term limits, especially on people like Dr. Fauci. And if nothing else, let's just pass one by him by name and don't let him ever serve ever again, or anybody else ever named Dr. Fauci. Let's just retire his uniform and hang it on the wall.
Yeah, I call it the one with term limits for staffers and bureaucrats. I call it the Fauci Amendment.
Yeah.
Let's just say there should never be a bureaucrat that accumulates 40 years worth of power in our federal government ever again. That just shouldn't happen. So I want to dig in a little bit on this issue. I put this out there to literally millions of people, Mike. I say millions. I mean, on Ben Shapiro's show, on Hannity's show, I know you talk about this all over the place too. And I've said, if you're a conservative and you can think of an amendment that you think would be bad for the country, then write the 38 states that you believe that would ratify that and email them to me. And I've given out my personal email address to millions of people. I've been doing that for 11 years now. And in 11 years, I've received a sum total of 0 emails, not even from the crazy people. Like nobody's ever been able to do that. If there could be a runaway convention and you could get one of these runaway amendments ratified, the idea that nobody in all of those years, and by the way, that includes the John Birch Society and Eagle Forum, they've never sent me the amendment that could be ratified by 38 states because it's just crazy. The one they say all the time, that's my favorite, Mike, is they say they're going to repeal the Second Amendment. This is absolutely my favorite because the math is so easy on this one. Currently, there are 29 states that are constitutional carry states. We usually add 1 per year or so. I don't know where that's going to top out. We got 29 states where you don't need a permit to carry a firearm. Go buy your gun, put it in your belt, put it inside your belt, and you can carry it. We have 24 states where you can carry your firearm inside the legislature. I've done it. Texas is one of those states. I've done it all over the country. You just walk in with your firearm. We actually have 14 states right now that have a law that allows you to take a long gun like an AR, loaded, put one in the chamber, sling it across your back, open carry it, and sit in the gallery and watch the proceedings. 14 states. Now, the idea that we couldn't get 13 states to push back on the repeal of the Second Amendment, that's just insane. And yet people still say it. Here's another argument that I get from people, though. The left is just so well organized, and the left is in total support of this, is what I'm told by these people. And they want a convention of states. What do you have to say to that?
Well, it's rare that the public statement of the left is exactly the opposite of what these people say. The people that I see working together is the John Birch Society lobbyist sits next to the Common Cause lobbyist in the state legislature, and they say the same things. They get up and they mouth each other's messages. Except for the bow ties, you'd never know which is which. And so it's just nonsense. The people, it's the people in the John Birch Society are doing what they accuse us of. They are carrying the water for the left. I don't think that they are leftists. I just think that they're lost. And I think the reason that they're lost is there's a certain kind of person that thinks the only way you can be a conservative is to hate everything and not ever want to do anything positive. If I would have done that, homeschooling would be in the shadows right now, and there'd be 84 people homeschooling their kids. And by the way, that's just 2 homeschooling families. And so, because we were willing to fight and go forward and pass laws to get recognition for our God-given rights and tell the government to get off our backs and go do this realistically, that's how we want. And people are walking in freedom. It's because we didn't hate everything. We hated the government coming into our lives. We hated a lot of stuff, but we didn't hate everything. And we're willing to take positive action. You can't, the people that are opposing us of this sort have never done anything positive their entire lives. They call themselves constitutional lawyers because they carry a little pocket constitution in their pocket. To me, a definition of a constitutional lawyer, the minimum, show me the number of laws you've had declared unconstitutional by a court. When you've done that, now you're a constitutional lawyer. Unless you've done that, or maybe you've defended one, I would take that. If you can be a state attorney general and be a legit constitutional lawyer and defend the laws. But unless you're arguing those kinds of cases that so-and-so acted unconstitutionally and you're winning some and you're getting stuff knocked out, you're not a constitutional lawyer. Maybe you had constitutional law in law school, maybe. If you went to Harvard, you didn't necessarily. It's not a required course. And so, but at Gonzaga it was. But the main thing is make sure you know basketball law if you want to go to Gonzaga. That's the main thing. So.
All right, Mike. So I'm going to start to wrap it up here. What I want to do is go back to Mike Ruthenberg and bring him on with us, or anybody, Mike, who's been watching the questions. We've got about 9 minutes left. So do you have any questions that seem to be recurring or things that we can answer that would really help wrap this up?
All right. Thanks, guys. You're really generating a whole lot of interest and excitement among the crowd. Really appreciate you guys being here. Kenny Neargard asked, is the 19 states application that has passed just for 3 proposed amendments, or I think he means topics mentioned? If we get to 34 states, go to convention, pass and or ratify one or all the amendments, do we now have to start fresh again if we want another amendment and get to 34 states again? Or can we have the convention open again for more amendments as long as they're germane?
Yeah, so I want to be clear. This is what's called a subject matter convention. We've specified 3 subject matter areas. So it's not specific amendments that have been proposed. And we as an organization are not proposing specific amendments. We're pursuing the subject matter convention. So it would have to be within those 3 subject matter areas. And if there was something that fell outside those subject matter areas, then you'd have to start over again and get 34 states. I believe that the second time will be easier because we will have done it. We will have proven it up. We will have the infrastructure in place to do it again if it's necessary. But it is limited to those 3 subject matter areas for germaneness.
And to follow on, Mike, I don't think you could come back for session 2 on our topics 5 years later. If the convention itself, adjourned for Christmas and came back in January, that's okay. But once the convention adjourns, it's done, because a convention is called for a particular time. And so I don't think it will be called for, a week or 2. It's going to be called for, it'll probably be 3 to 6 months long, would be my guess. But the ending of the convention is the ending of its authority. And if we're going to have a convention, whether on any of our topics or any other topics, you have to start over. And like Mark said, the second time will be so much easier because we will have disproven once and for all the runaway convention idea. And so that's one of the best things we can do. Even if we get, just one really good amendment out, we would have done so much for the country by showing that we can do these conventions in the future and curb the power of the federal government. It'll be great. I think we could call them more readily and have, particular, very narrow topics. Like, let's say you wanted to do one just on 9 justices. You could get that through probably in a year. If you right now, that'd be something that'd be easy to do. As a second convention.
So we're making history and greasing the skids for future conventions. I love it. Michael Holt asked this question, and the reason I'm going to pose it is because there were some other people on both sides of this topic, but I don't think the actual topic is the real meat of this question. Here it is. Why can't we call for a repeal of Citizens United when talking about the goals of COS?
Citizens United is about the First Amendment rights of the people. And it's not about limiting federal power. And so the central holding of Citizens United is the nature of who you are as a person, whether you're a juridical person or a natural person. You have the right to freedom of speech. And so if there are people on the left that want to curtail Citizens United, and they've passed COS applications in 1 or 2 or 3 states. I don't know. It's a really small number. They're nowhere near where we are. And if they could get 34 state legislatures to call for a Citizens United convention, you could have a Citizens United convention and say that that people can't join together and have free speech together, which is what a corporation is, whether they're nonprofits or for-profits. And so the churches churches are juridical persons. Churches wouldn't be able to say what they want to say, and so, but whether it's a good idea or a bad idea politically, it is not a relevant idea. It's not germane in our call.
And I just want to add to that. It's important to think about our call. Everything is limiting the power of the federal government. If you remove the federal government's ability to restrict campaign speech, which is what it would do to overturn Citizens United, it would actually give the federal government more power to regulate campaign speech. And our convention, everything is limiting the power of the federal government. I want to say one last thing about Citizens United. It's the greatest modern free speech decision in modern history. And I think some conservatives get confused by this because they say, oh, we hate money in politics. I just want to be really clear. This was about conservative money in politics. The Democrats, the leftists, always had money in politics, and they could conglomerate money like this through the unions. The unions collect millions, hundreds of millions of dollars in dues over the years, and they're able to spend that money collectively on politics, even against the wishes of their union members. And this was actually kind of leveling the playing field in a way that the left really didn't like. And I think there's some history that's really important here. I've been studying this recently, Mike. This actually comes out of Ronald Reagan's Time for Choosing speech, one of the most important political speeches in the history of the conservative movement. Reagan is not running for anything at that point. He's standing up and he's speaking on behalf of Goldwater. And several businessmen got together, bought TV time, and paid for Ronald Reagan's Time for Choosing speech to be broadcast. If you've never watched the speech, I highly recommend it. It's one of the best, most effective political speeches in history. After that, the Democrats were really mad about that. And so they put in a bunch of campaign finance laws that would prevent that from ever happening again. And those finance laws stayed in place for decades until they were overturned in the Citizens United decision. So that was a free speech decision intended to, really, from my perspective, intended to free up conservatives to speak on an even par with what the left was doing through the unions.
Thanks so much. This question is from Richard in South Carolina, and it's regarding the 16th Amendment, or the authority that has been given to the Congress to levy taxes. He says, there seems to be some reasonable rebuttal to, or some argument that it was not legally ratified.
I've held the ratification documents for every state for the 16th Amendment in my hand. The realism says the chances of the Supreme Court ruling any of our existing amendments to be illegally ratified because of technical arguments is 0. And so, we have a far, 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 far greater chance of getting rid of the 16th Amendment, which I'd love to do by our process. The other is you would have to have not 5 people on the Supreme Court that are as conservative as I am. And that's just, that ain't going to happen anytime soon. President Trump appointed the best justices of my lifetime, but they're far from what you need to get this kind of stuff done.
Yep. All right, Mike, Farris, anything you'd like to say in closing? We're about the top of the hour here.
Well, I've been watching the questions roll by. I love the energy. I love the enthusiasm, and we've got resources that people can get a lot of these questions answered. We've got leaders who can help them answer those questions, but keep the enthusiasm going, because we can take back this country. If I could encourage everybody on this call to do one thing, and that is help your neighbors understand this. Your state legislator has the ability to stop the federal runaway spending. If your state legislator is not doing something to stop the federal runaway spending, they bear every bit as much responsibility as the people in Congress. They have the ability to take away the checkbook. And if they're not doing it, shame on them. So, start asking the question every time you meet a state legislator: what are you doing to stop the rate of runaway spending in Congress? You can do this in Article 5. And, there's a lot of other kind of runaway, but everybody gets to runaway spending. Put the burden of that on the back of state legislators, starting in Iowa, in Ohio, in South Dakota, in Montana, and Wyoming. What are they doing to stop the runaway spending in Washington? They can do it, or they can do nothing, and they're responsible.
Yeah, and Mike, I would just close by saying it's such an honor and a privilege to sit here with you, Mike Farris, and you, Mike Ruthenberg, who were here at the very beginning. I remember sitting at that resort in Scottsdale when you presented this to our board, and seeing where we are now, having millions of people participating, your vision of being in all 50 states. Mike, you go around all these state legislatures now, you see what I'm about to say, which is there is literally no legislator in the United States of America who's a state legislator that's been there a term that doesn't know what convention of states is, because you folks who are watching this, you're the point of the spear. You make the contact. You're in their offices. You're sending the emails. You're having the conversations. Mike Farris and I, we go around, we go to these legislators, or we go on TV or whatever. You guys thank us. You guys are doing the work. The only reason the legislators listen to us is because you guys go there and you set the stage for us. If you weren't there, they couldn't care less about us. If you weren't there, nobody want to listen to me or Mike on the radio talk about this. It's because they know the Army is in the field. That's you. And we appreciate you and love you. And we're going to get this thing done. We are going to get it done.
Thank you so much, Mike and Mark, for being here. And to dovetail on what Mark just said, I want you guys to look out in the Friday newsletter, the Leaders Roundup. There's going to be a brand new edition of our Grassroots Groundbreakers. And we're going to have Bill Giaffredo, a state grassroots coordinator from the state of Connecticut, talking about responding to questions and objections with COS. Here's a man in the grassroots that learned what's going on. It's making it happen. It's going to make it much more easy for you and your teams to be bold. This is a man who since August 1st has brought in over 68 petitions himself. And he knows how to talk to people and answer the questions that people have, answer the objections. So you want to keep your eyes out for that Grassroots Groundbreakers coming up on Friday. Thanks again for being here. God bless you all. God bless you, Mark. God bless you, Mike. Have a good night, everybody.